The committee of the whole is back in session. Senator Esperon, you're recognized.
Thank you, Mr. Chair. Just two questions. Mr. Recchi, is Koku interested in extending its lease past 2023? I mean, do they expect to remain in business and continue on and perhaps needing a place? I mean, I guess the point of the question is there a possible remedy somewhere along those lines, or at least an offset to the 7.5 or the 5, let's call it almost $6 million that we would now have to try to figure out how to compensate?
I can't really specifically say because I haven't discussed that with my client, but I can say that the current lease agreement with some of its restrictions and limitations really makes it unworkable, and some of the provisions that we included in the amendment, for example, expanding the activities to be used for using it for a laydown yard or construction. You know, I think Koku felt that if it could gain some money from the property through lease, through conducting other activities on there, because the original license agreement was rather restrictive. So that was the whole purpose in suggesting the amendments. That and perhaps making the agreement, clarifying on the term of the agreement, that kind of thing. Well, but right now it's so limited that without some of those amendments, which I honestly felt in prior years, at least some of them, I think they were all pretty much, had thought they were agreed to, but some of those, like those, didn't seem to be controversial. Extending it for a few years, making it 2 years longer, broadening the activities. But I think without, or another one was exchanging lands. That was something we put in there, so perhaps CLTC could say, well, you know, give Koku some other lands to work with. That was an option. That's why that provision is in there. But without all of those options, there's nothing attractive about the license agreement because it really can't be used for much of anything right now. So as a business opportunity, I'm just, again, I haven't discussed this specifically, you know, with Mr. Bello, but I think it's hard to make it workable unless some of those amendments were made.
Well, you know, since you opened that door, I'll ask another question, a follow-up question on that one then. What exactly were the restrictions that the Koku cannot perhaps operate to the optimum level that they could so as they would become perhaps more profitable?
I think one is definitely the activities that are presently permitted. Let me take a look at that for a minute if I can.
Can I just ask how large this property is, Mr. Bora?
You know what, I can't answer that without looking at the license agreement.
Well, is there a ballpark?
5.5 acres.
5.5 acres, okay. And anybody know the zoning on this one?
Well, something like this would have...
It is commercial.
It is commercial. Under a commercial designation, Mr. Bora, maybe you'd be the best guy to answer this. Are the activities of someone like, of an entity like Koku, are those activities, I suppose, of taking in debris, taking in trash, and I'm not sure even what kind of debris and trash we're talking about, whether, you know, paints and things like that that may have some toxicity to it. Are they allowed to do those kind of activities on a commercially zoned property?
Again, I'd have to refer to the statute, but there are certain conditions. There are actually a lot of different conditions that can be permitted under a commercial. Something like this would more likely be an industrial zone, right. But there are a lot of different conditions that may be applicable. This specific case, I can't tell you exactly what the zone and conditions that might apply to it are. I can get you that information, however.
If there was another piece of property that was available to Koku that they may be interested in looking at, is there a piece of property like that within the inventory of Chamorro Land Trust that would be more amenable to this type of a business, that probably doesn't sit over the aquifer, that probably is not within a certain radius of residential properties and things like that. I mean, and again, I ask that because that's what's being contemplated in the recommended terms of the amendment.
There are, I believe, 7 or 8 different lots, predominantly in the northern part of Guam, that have been designated for commercial use by the Chamorro Land Trust Commission and technically approved by the Guam Legislature as well, all done in accordance with its commercial rules and regulations. We'd have to look at one of those, perhaps.
Okay. Mr. Leon Guerrero, in terms of, like, you're familiar, probably, I'm sure, with collection of waste and things and debris and things like that. What are some of the, maybe 1 or 2 top concerns that EPA might have in terms of these kind of business activities?
So with our permit process, what we'd have to do is ensure that depending on the waste that is, or the recyclables that are collected and the potential of contamination that can be associated with those recyclables, that's where we would make sure that there's mechanisms, excuse me, mechanisms in place that will not let any potential contamination off the site or even impact the environment.
Mr. Arecki, so I would imagine that, and again, the Koku's main business is recycling. Is that correct?
Yes.
And so you're saying that the lease of the property, the lease, the license of the property really doesn't allow Koku to fully do the recycling job that they think could optimize their business?
Well, there are, of course, a lot of other companies that do that work too, but I think the thought was that other activities, you know, such as lay yard, storage of materials for lease, because the license allows leasing out.
Okay, so subleasing basically out.
So it was other ways to to raise funding or make the property more commercially viable.
Okay, and that would be the consideration if they were even interested in taking a look at another piece of property to which to operate out of.
That was an option.
But if those conditions were changed, would it be necessary to take a look at another piece as opposed to just remaining on this particular piece since it already has been used as a recycling location?
The other activities would oh, I'm sorry. The other activities would certainly help.
Which would allow them to stay on this particular piece?
Possibly.
Okay. One last question, Mr. Chair, and this would be to the Attorney General's office. The Attorney General's office basically protects the government and raises issues, legal issues, where perhaps we have overstepped our boundaries. In a particular case, and we'll even use this as the example, since if this bill is passed the way it is, and we know your position that there is a possible, probable constitutional issue, would that be a case that the Attorney General would then on its own forward to actually contest the validity of this law?
I think there's a definite possibility of that. You know, we have a new Attorney General being sworn in January, and of course, you know, we have not talked to him about that.
Right.
But under the current situation, I would say, you know, yes.
Okay, and I appreciate that. I mean, because I would imagine the expenditure of $7 million or whatever that amount is, 6, 5, whatever it is, in times of fiscal constraints, right, I think that would be an interest to the public, right, of making sure that we don't unnecessarily spend, especially if we did it by an act that may be unconstitutional and inorganic, right?
I think that's a factor that would be considered.
Okay, and I appreciate that. Mr. Chairman, I have no more questions. Thank you.
Thank you, Senator Esteban. That'll conclude our listing on round 2. Senator Rodriguez, you are welcome to provide closing remarks and proper closing questions to this panel before we dismiss the panel and proceed on to amendments and discussions. Senator Rodriguez.
Great. Thank you very much, Mr. Chairman. Again, to everyone, thank you very much. I know it's been a very long day. I'll make this very quick. So there's 2 issues here. One is the separation of power and the potential of portions of this bill being inorganic. And so the question I have is 2 questions for the AG. One, or before I get to that, Mr. Orcutt, you had answered a question earlier by the Vice Speaker that by looking at the proposed amendment that's in the bill, that you answer that it may create a liability for the government if that is passed, as it's written in the bill. That's correct?
Correct.
Okay. So based on that, and based on just on your first review of the license agreement, which you have seen already by now, right?
No. What I'm talking about is a proposed bill. Maybe you're saying the same thing.
Okay.
I'm not sure.
Yeah. So the first question is, but on the license agreement, this is part of the license agreement. It says, as licensee has been providing cleanup services for the lot 10, for the lot in Deredo that we've been talking about, the CLTC shall accept as credit all metallic waste removed from said lot to date, which has been determined and agreed to be in excess of 25,000 metric tons. In addition, any further and future cleanup work on the lot or CLTC property shall be credited towards rental payments at the $20 per cubic yard rate. So just based on that, the same assessment you use on the provision on the bill, the proposed amendment, would you say that is already a liability of the government?
I couldn't answer that. You're I'm sorry. You're reading from the original
license agreement.
Yes, I would not feel comfortable commenting on that at all, having not reviewed the document.
Okay, so I just wanted to bring that up because I think there's some inconsistencies there. The bill has that proposed amendment, and based on your review, you say that it is a potential that it creates a liability.
Yeah,
this one here, and I'm asking the same, pretty much the same
yeah,
thing.
I've read the bill. I haven't read the original license. I'm sorry.
So, so, Mr. Chair, just based on that, there's 2 things here. One is the separation of powers issue. The other is the payment, the actual compensation. If the body does recognize that there is that compensation, I just want to ask, and this is the final opportunity we have of Mr. Jarecki, on the issue of separation of powers, because it's only been brought up during the public hearing, the first time we had a public hearing on 350. I want to just get your perspective on that, because as you have approached our office and approached Senator Ada's office, that was never been an issue. So I want to just get your input on that.
Yes, thank you, Senator Rodriguez. I had the opportunity over lunch to review the 2 cases that the Attorney General cited. And of course, lawyers often disagree, but I am firmly of the belief that Section 2 it's not organic, and it does not violate separation of powers. There were 2 cases the AG cited. One was the in request of Gutierrez. What that case was about was Governor Gutierrez sued to hold provisions of the Budget Act unconstitutional. The legislature had identified positions in the government that the governor could fund, but only those provisions. So the governor was not allowed to fund other provisions that the legislature hadn't included. The court said, yes, that violates separation of powers because you have directly put a restriction or prohibition on another branch of government. The legislature had actually restricted the power of the governor. Look at Article 2. Article 2 doesn't restrict the Chamorro Land Trust Commission at all. It doesn't prevent it from doing anything. It doesn't require it to do anything. If you look at the provision, what it says is that the legislature gives an authorization and recommends that the CLTC make those amendments. If the is the CLT free not to make the amendments? Yes, no obligation. It's only recommendatory. So it does not meet the requirement of In re Gutierrez that there be a restriction on a governor or another branch's power. There's no restriction here on the CLTC. And the other case that was cited, that's the Arkansas Fish and Game or Fish and Wildlife. That was a completely different situation. There, the legislature had passed a bill that said to an agency, every contract you pass must come to us, the legislature, for review. Do we have that here? Is the legislature demanding any further review of the CLTC agreement? No. So the reason in the Arkansas case that it violated separation of powers was that the agency, by merely having to submit its contracts to the legislature, that was an infringement upon the right of the agency to contract. We have absolutely none of that here. So my opinion is I don't see that this provision in any way violates separation of powers. But I would also say, I think Senator Espaldon had, a possible solution. If one says that that provision does, or you're concerned that it does, you could consider amending it. That's something you could. But I guess legally, I really feel that it's not organic. It doesn't violate separation of powers. And I have to say again, these provisions were really discussed a lot over the years. I thought they were beneficial. I thought they were helping to clarify the term of the contract, the scope of activities to make the property more usable. And so there was a lot of discussion. And I have a letter in the materials I sent to the legislature that was addressed to CLTC Director Mofness. You can see I was writing him back and forth. We were actually looking at the amendments, sending them back and forth, and he had requested a revision. And then I wrote him and told Mr. Mofness in 2011 that Mr. Bello had executed the amendments, and then it was back for them. Both he and Mr. Oscar Calvo had told us they didn't have a problem with the amendments. So I think the amendments are somewhat beneficial. Whether you want to recommend them or not is certainly up to you, but they had a history, and there was some agreement on them. So, but I've stated my position. I don't believe they're inorganic.
Thank you very much for that. And so the second and final issue is the source of funding. And Mr. Leongara, I truly appreciate your testimony here and understand your position on it. And so that's going to be up to this body here. And we're going to continue to move forward to identify and use that source, or if there's another source. So thank you very much to you as well, Mr. Borja, and to the AG's office for being here. And Mr. Chairman, I think we've exhausted at least the questions now. And so I would move that we excuse the panel and that the body continue to move on with any amendments.
Thank you, Senator Rodriguez. The motion is not necessary. That was part of our agreed upon rules of engagement. And so that being said, I would like to at this time...
Sorry, Mr. Chair.
Are you raising a point of order, Madam Speaker?
Yes.
State your point of order, please.
I thought we were going to have 3 rounds.
No, the rules of engagement were specifically for 2. If there's a motion for a 3rd round, we will definitely entertain one. Would you like to make that motion?
Yes.
There's a motion for a 3rd round of questioning.
I just have a couple more questions.
There's a motion to open up for a 3rd round of questioning. On the motion, are there any objections? There's been an objection on the motion. On the motion for a 3rd round of questioning, all in favor, please indicate by raising your hand. Motion fails. We will conclude the question segment of this panel and go ahead and dismiss them. Please remain available on the exterior in case any members have any offline questions for any of you prior to we concluding the amendment and discussion portion of our Committee of the Whole. This takes us now to our amendment and discussion period of the Committee of the Whole. The panel is now dismissed. If the Sergeant at Arms could please provision for the panel. Thank you all very much for making time to be with us all day today. It is much appreciated. Thank you. Thank you. Colleagues, on this next segment of our Committee of the Whole, we are open for any amendments or discussions. The floor is open for recognition. We'll yield to the author of the bill if he has anything that he'd like to move initially? And if not, then we'll yield. You yield? Colleagues, the floor is open for any amendments or discussion on Bill 350. Any amendments on the bill? Amendments or discussion? Any amendments or discussion? Senator Nelson, you're recognized. Okay, Senator Nelson will yield at this time. Any other members have any amendments or discussion on Bill 350? The floor is open for any amendments or discussion. Please be advised, colleagues, as per the advice of legal counsel, we are attempting to complete this committee of the whole prior to the 6 p.m. hour, closer to the 5:45 p.m. hour if possible. So if you have any amendments or discussions, the floor is open, and we await those patiently. The floor is open. Senator San Agustin, if you'd like to have any amendments or discussion. Yes. Senator San Agustin, you are recognized.
Thank you, Mr. Chair. If the author would yield, I'm the co-sponsor of it, but I just want to make sure that we have clear clarification of exactly what's in the bill. Number one, the bill recommends or authorizes and recommends the CLTC to change the lease or the agreement they have, and identifies a source of funding to pay. Am I correct with the author? Just
Senator Rodriguez, do you yield?
Thank you, Mr. Chairman. Thank you to our good colleague. Yes, it does two things. Section 2 of the bill provides for the authorization and recommendation for an amendment to the existing license agreement. And as we've heard, that may be the point of contention on the separation of powers issue. And so if there is a move to strike that, I don't have any, I won't object to that. And the other part of his question is that Section 3 of the bill provides for the source of funding and the appropriation as to how we're going to cure the remaining I think close to $6 million that is payable to COCU for the work that they've done based on the license agreement that has been signed and executed and the liability that has been created from that.
Senator San Agustin, are you satisfied?
I just want to make it very clear for the people of Guam that's listening. The bill authorizes and recommends the CLTC to adjust the agreement they have, and there's a source of funding to pay for the liability that everybody has admitted it. other than the Attorney General's office saying there's maybe inorganic separation of powers. You know, there's always separation of powers when it comes to us, but we're the one that decide what powers exist. But I'm just concerned is that I just want to make sure that we clearly understand that if we identify the source of funding today, and let's, for example, next year, there's a new body, and it wants to identify another source of funding, it's possible. Right. It's not like it locks in the EPA to pay this. And I'm just concerned that EPA never made an effort through all the many years to pay off this liability. It has reached a point where it became a bill to pay it. And they can't say they've been short on money because they've always had money. And the mayors have always used their source, and they're the one that was identifying the items that needed to be disposed of. And the government took upon himself. Thank you, sir.
Thank you, Senator San Agustin. Are there any members who wish to proffer any amendments or offer any discussion?
Just a point of information, Madam
Senator
Mr.
Nelson,
Chair.
you're recognized on your point of information.
It is not EPA's initial responsibility to pay for this. The licensing agreement was agreed upon between Chamorro Land Trust and Cocoa Recycling. So EPA has no real jurisdiction in this cause. We are looking at EPA because we are adjusting the recycling revolving fund that falls under the administrators of EPA. And the recycling revolving fund now has promulgated rules and regulations, EPA has now promulgated rules and regulations for the recycling revolving fund, which will be heard tomorrow in a public hearing. Thank you, Mr. Chair.
Thank you, Senator Nelson. Colleagues, do we have any amendments to Bill 350 at this time? Acting Speaker Terlahi, you are recognized.
I have a point of order. I think we have less than a quorum here, and it seems obvious to me that the members are either busy or they've got something else to do tonight. I would ask, Mr. Chair, that you recess us until tomorrow at 9 to continue when everybody's here.
If I'm not mistaken, I believe Senator Lee is still with us, and we do have a quorum. But on that motion, Madam Speaker, just an advisory, I have been informed by legal counsel that in the interest of ensuring that we are able to make our engrossment deadline for tomorrow, and that we are able to recess our session, and Senator Lee's present, recess our session and be able to meet our potential veto override deadlines that are a potential from Megalahi, we would need to conclude our proceedings this evening at earliest so that engrossment can take place and voting can commence. I wanted to advise that with respect to your motion to recess at this time.
Well, it wasn't a motion, it was a point of order.
Point of order.
Stating the lack of a quorum and asking you to recess us.
I see. The quorum has been reestablished. Do any of my colleagues have any amendments on Bill 350? Do any of my colleagues have any amendments on Bill 350? If there are none, we could entertain a motion to advise and rise from the Committee of the Whole. Are there any amendments to Bill 350? Acting Speaker, you are recognized on an amendment to Bill 350.
It's very hard to pass any amendment right now because we only have 8 people here and it's very clear where their allegiances are lying. But I would like to ask that...
Acting Speaker, you will refrain from making comments about our colleagues in such a manner.
Mr. Chair, you have cut me off from asking questions of the panel. You've cut me off from the middle of my questions when they were here. Acting Speaker, you have the floor with respect to amendment on 350. You will not recess us till the rest of the members are here. So I wanted to bring up this issue. If Section 2, some of the arguments that have been made that Section 2 of this bill, first of all, I rise in objection to this bill. This bill very clearly intends to create a liability for the government of Guam that does not exist at this time, that is not recognized by the Chamorro Land Trust, which is the party to the only potentially legally binding document that we have been shown. It's the license agreement. And there's not even been an opinion by the Attorney General to the Chamorro Land Trust or to us that that document is binding, but even if it was, the maximum amount of liability for the Chamorro Land Trust Commission pursuant to that license is $1.6 million. But this bill would extend liability to the government of Guam to $7.5 million. And I don't believe that we should be in the business of doing that without any court order ordering that the government of Guam is liable, with our, at the very least, an Attorney General opinion stating that this is an obligation on behalf of the government of Guam. In fact, they're saying the opposite, or that they're saying that it's possible that that is not the case, and that this bill would absolutely be the instrument that creates that $7.5 million liability. And I know it's Christmas time, but I don't see any reason why we are going to play Santa Claus with the people's money, the money that they've been putting aside, $25 for every single car, every single registration goes to this recycling revolving fund. It's been, you know, finally, we've been criticizing the Guam Environmental Protection Agency for not using that fund for its intended purposes. The people of Guam have been criticizing us for using that fund for other than the Guam legislatures, and I would say before my time, those legislatures sent that money elsewhere other than for recycling purposes. And I for one am here because I want to ensure that this money gets to its intended use, that it is used for our future cleanup of Guam, future programs that they have finally done all the work to put into place. These programs are, I mean, we went through the list of them, and I just, you know, it baffles me that after we criticize the Guam EPA for not getting on the ball and getting these rules and regs done, tomorrow they're having their hearing on the rules and regs, and we have given them the money. We have already appropriated this money to them, to the Guam Environmental Protection Agency, to implement all those programs. This bill would instead, in the middle of the game, while they're just about to implement their rules and regs, this bill would take that money away from them and give it to some past debt that is still not proven. And I just think that's a gift that we cannot afford at this time. And if there comes a time when this debt is proven and owed, then that legislature, will have to find a way to pay that, just like that legislature has to find a way to pay all the other existing liabilities that it owes to people in Guam. For example, land condemnation. And it's been said that the AG told us that this bill is inorganic, unconstitutional, it's a violation of the separation of powers, among other things. But some of us are arguing that Section 2, because it says it's an authorization and a recommendation, that it's really not binding on the Chamorro Land Trust Commission. So if it's not binding on the Chamorro Land Trust Commission, then I would move that we just delete it from this bill. If it's some optional thing that the Chamorro Land Trust can do or not do, then we should delete it. But I want to show the fallacy of that argument, that this is really not that of those people who are saying that this bill is not unconstitutional, that it's not mandating them to do anything, because even if we removed Section 2, we still have Section 3 of this bill. And Section 3 of this bill is really the meat. It's really what everyone's after, because it's the money. This is the continuing appropriation of $590,000 every year. I think $598,000 in FY19, and thereafter $590,000, $500,000 every year from our recycling revolving fund. To fund, it says on line 16 on page 7, shall be appropriated to fund a prior year obligation. This is where we are setting in stone that there is a prior year obligation where no one has been able to prove that or come to us to show that obligation. So we are appropriating to fund a prior year obligation, and if you go down to 19, line 19, according to a license agreement established in 2001 between cocoa recycling and the CLTC. But this is absolutely contrary to what the Chamorro Land Trust Commission has asked us, has recognized among itself. They have only they do not recognize this liability. They will be meeting their liability by allowing cocoa recycling to remain on their property until 2023 and to be not paying any rent. The rent they were supposed to pay was $6,600. But the Chamorro Land Trust, I think, has been, they've allowed them to stay until they are allowing them to stay until 2023 without any payment of even a single dime to the Chamorro Land Trust because they were supposed to clean up. But what has happened is this, we found out that instead, the property's not cleaned up. And the property in Vergara is actually under current violation with Guam EPA.
Point of order at this time, Mr. Chairman. I'm sorry to have to make this, but we are definitely without quorum right now, so I would have to at least raise the issue. I'm interested in what the speaker has to say, but I think it would definitely behoove us all to, the members of this body, more members of this body, to hear the argument that she's putting forward. So at this point in time, I would motion to recess until tomorrow morning. Only because we have no quorum, Mr. Speaker.
Mr. Chair, I think the importance of us being able to vote by the time that we've set out as a body, that if I hate to do this, but if we have to do call of the House, then I would prefer we do that than recessing. I think perhaps we take a short recess to see who's in the building and to call them in.
At this time, because the quorum is not present on the floor, we are unable to attend to any motions. The chair will suspend discussion for a period certain to determine from Sergeant at Arms if the members that are supposedly present are still, and if they are not, then we will have to suspend session until a period certain. Would the Sergeant at Arms please identify if we do have a quorum present in the building or not? Senator Espadon, your notation has been addressed. We have confirmed the members are present in the building. We will proceed with the discussion on Bill 350. Do any of my colleagues have any amendments that they'd like to proffer on Bill 50? Acting Speaker Terlahi, you did have the floor. You did make an initial motion with respect to striking Section 2, and then you proceeded to discuss Section 3. You may continue over discussion on Section 3 or proceed with your amendment on Section 2 at your leisure. The floor is yours, Acting Speaker.
As I was saying, there's been some discussion that, by some of the members that notwithstanding the AG's opinion that this bill is unconstitutional and inorganic, that it violates the separation of powers, that because Section 2 is optional, that we are recommending the Chamorro Land Trust to do something that you know, it's really not forcing them to do anything. But I was directing the members' attention to Section 3 in conjunction with Section 2, or even standalone. Section 3 by itself is really the meat of the bill. It appropriates $598,000 for FY19 and $590,000 for every year thereafter. This is something that the government of Guam is not currently obligated to do. And it says it shall be appropriated to fund a prior year obligation. So this language, again, is recognizing a prior year obligation that nowhere else in writing does the government of Guam recognize, formally recognize. So it says it's to fund a prior year obligation for removal of metallic and other waste by Cocoa Recycling, Inc. from Chamorro Land Trust lot number 10122-15 Dedido, according to a license agreement established in 2001 between Cocoa Recycling, Inc. and the CLTC. So now this language is saying that that 2001 license agreement is what we are using to pay the $7.5 million additional obligation, over and above what the Chamorro Land Trust Commission says they are potentially liable for, which is $1.6 million. That if you add up all the lease payments up to 2023 and you give full credit for all of those lease payments that Cocoa should have been paying to the Chamorro Land Trust, if we give them credit for all of those lease payments, it would only total 1.6. But this Section 3 is putting in writing that there is a prior year obligation of $7.5 million established between Cocoa Recycling and the Chamorro Land Trust Commission. And that is the reason I object to this bill. It's the reason why, I mean, I guess I would amend my amendment and move that we delete Section 3. And that if we give Chamorro, we leave Section 2 and give Chamorro Land Trust, I'm just kind of being joking here, and we leave Section 2 and we give the Chamorro Land Trust the option of creating a new license obligation for $7.5 million, you know, we can leave it at that. But we shouldn't create that by statute or by law by putting it in Section 3 of this bill on page 7. So I would move that we delete Section 3.
There's been a motion on the floor to amend Bill 350 by striking Section 3 beginning on page 7, line 9. On the motion, Senator Rodriguez, you're recognized.
Thank you, Mr. Chairman. Mr. Chairman, I, of course, object to that motion. I think the mover of the amendment, if you're going to reference what the Chamorro Land Trust is saying, if you're going to reference the 2001 license agreement and say that the only liability that the Chamorro Land Trust has is 1.6 because that's what that license says, read further. stop trying to put out statements that support just what you want everyone else to believe. Read the document. We've been saying it all day, that there was an admission of the work that was performed. And this was signed by the Chamorro Land Trust and Coca Recycling. And so it's just misleading. It's misleading to our colleagues and to the public that you're going to reference one part of the agreement but not go further and reference what the agreement is saying, that the work has been done, 25,000 metric tons of work has been cleared, and that equates to 7.5 million. So I object to this amendment.
It's been moved and objected that we strike Section 3 of Bill 350 on page 7, starting on line 9. Any of my colleagues have any further discussion on the proposed amendment?
Mr. Chair, it's also been said
Senator Nelson, you're recognized.
Thank you, Mr. Chair. Mr. Chair, it's also been said that Chamorro Land Trust entered into this agreement. Nowhere does it say that the Recycling Revolving Fund through EPA was entered into this agreement. It was also stated that they went out of the scope of work. In many instances, they did job performed that they were not agreed to do. So how can we put this burden on the people if there was no due diligence in a business who knows how to, and people who know how to operate businesses? They have bylaws here, they have rules of operations in their bylaws, and now we hear a statement saying there were discussions with various Chamorro Land Trust executive directors. I'm thinking Department of Land Management directors, but there's no evidence of this conversations taking place throughout the years. And so I stand in support of this amendment.
On the amendment, any further discussion? No further discussion. The mover of the amendment is welcome to close.
Thank you. I have listened patiently all day and through the hearings on these bills and the iterations of this bill prior. And even if the Chamorro Land Trust admitted that work had been performed which exceeded the amount of the lease payments, does that create a debt for us of the $7.5 million in cash? And are we going to say that these sophisticated parties, when they were looking at this license that said $6,600 for 20 years, and that this license very clearly ends in 2023, that it actually doesn't end in 2023, and it goes on for $7.5 million more than what it said on the face of the agreement? It goes on for potentially, 50 years, they said, to pay this off? That's what they really had agreed to? I find that far-fetched. The parties, they agreed to the term. And if the terms conflict, they keep reading that one portion that says that they had done so much work, yet in the same document, despite the work, in the same document, they were capping their liability at the rental payment amount. And I think why I'm very comfortable in going this way is because the Chamorro Land Trust Commission, if they really thought there was a greater liability, they would have approved the amended license. They say they have that authority, but they never approved that. And the chairperson of the Chamorro Land Trust Commission has made it very, very clear since 2011. I think it's been presented to them, this amendment to the license agreement that would, increase the debt to $7.5 million, that they have never approved that. Also, there has been no claim. And if there really existed on the face of the license agreement a debt for $7.5 million, I cannot believe that the company would not have claimed in the last 17 years for $7.5 million, put a claim into the government of Guam or filed litigation. I mean, we've had companies filing for much less than that for much shorter periods. And so, you know, I can see that if the claim is not good for some reason, that they're going to come to the legislature, but I'm just saying, please, this is the people's money. It's hard-earned money, you know, that they've sacrificed to put aside, and I think they willingly do that because we all want to take care of the precise issues that Recycling Revolving Fund is supposed to address on Guam. So I'd please ask my colleagues to please support this amendment. Let's not use the Recycling Revolving Fund to pay this past debt. Let's not use the Recycling Revolving Fund. Let's not depart from where that fund's supposed to be used, and let's not create a debt that the government does not clearly have right now. When that is clear, then, you know, we can scramble to find source of payment, and we are going to make big sacrifice to pay $7.5 million. But I think that day is just not today. Thank you very much, Mr. Chairman.
Thank you, Acting Speaker. Any other, I'm sorry, that was your closing statements. We will call for the question on Section 3, the striking of Section 3 as moved by the Acting Speaker. There's been an objection. All in favor of striking Section 3, please indicate by raising your hand. Motion fails. Acting Speaker, you continue to have the floor. You continue to have the floor, Acting Speaker. Acting Speaker, you continue to have the floor.
Just a point of order, Mr. Chair. By the way, you're doing a great job up there. No, we only had, I think one of our senators stepped out to use the restroom. When you called the vote, I'd request that we do a revote.
Will the Sergeant at Arms please ensure the quorum of the House?
Are we in recess or not yet? Or may
The chair is suspending.
Oh, okay.
Senator Nelson, that a motion to reconsider the actions of the body. There's been a motion to reconsider the actions of the body with respect to the amendment as proffered by Acting Speaker. On the motion to strike Section 3, all in favor, please indicate by raising your hand. Motion fails. Acting Speaker, you continue to have the floor.
Thank you, Mr. Chairman. I would move that on page 5, there's a Section 4, lines 20 through 24. This provision would grant a much broader use of the property than is currently being allowed. It would allow, in fact, for a hard fill, which is where they throw things in the ground, put cement on top of it, storage and warehousing, operation of construction office, and storage and sales of construction and building materials and equipment, and laydown yard, in addition to a solid waste processing facility and a solid waste management, disposal, and recycling. And the administrator from the Guam EPA has said this far exceeds their current authority. In fact, they have no current authority because their permits have been revoked because they're in violation. And the Chamorro Land Trust Commission administrator has said this would far exceed their current authority or even the intention of the original license agreement. So what I would ask that they not be given this authorization to extend the uses this way. I think this is it's very contrary to what we are trying to do with our recycling revolving fund, and that we should not allow it, especially in this manner where we're not able to investigate it any further. So I would move to strike section 4.
There's a motion by the acting speaker to strike on page 5, lines 20 to 25, the item that is section 4 under the master section 2. On the motion to strike that subsection 4, Senator Rodriguez, you're recognized.
Thank you, Mr. Chair. Mr. Chair, I don't object to the motion to strike. However, I want to make a correction. You know, if we want to talk about facts here, we got to talk about facts. Earlier, it was brought up, and the mover just brought up that allowing them to use it for a hard fill or for all the other purposes that's listed in item 4 of this is exceeding what the license agreement had already, or any previous authorization they weren't given. I refer our colleagues to the packet, the committee report packet, and in February 2002, there was an authorization to COCO Recycling to obtain a hard fill permit for that said lot. And so again, another one of those inconsistent statements that are being put out there without knowing the facts of it. But I don't object to the motion.
Any other members wish to be heard on the motion to strike subsection 4 on page 5? No other members being heard, no objections being raised. Subsection 4 on page 5 is hereby stricken. Acting Speaker, you continue to have the floor.
I guess I would just reiterate my opposition to this bill. I think this is not the time to incur an additional liability for the government of Guam, and I think it's premature, and that if all the facts as have been stated by different parties but are not in writing are found to be true when a claim is submitted or litigation is filed, then I will stand with the legislature to find a solution to that obligation. Thank you very much.
Thank you, Acting Speaker. Any other members wish to be heard on Bill 350? Any amendments wish to be proffered? Any discussions? If none, we will have exhausted our procedures on Bill 350-34. Do we have a recommendation to rise and place Bill 350-34 into the third reading file for consideration by the body at large? Senator Rodriguez, you're recognized.
Yes, thank you very much, Mr. Chairman. Thank you to our colleagues. I move to rise in the committee of the whole with a recommendation to do pass, or if that's not the right, that's not in order, at least place it on the third reading file. The Bill 350 as to do pass.
There is a motion that we rise from the committee of the whole with the recommendation to do pass Bill 350-34 on the third reading file. On the motion, are there any objections?
With amendments intact.
With amendments intact? With amendments intact, Acting Speaker. On the motion, are there any objections?
Well, I'm objecting to the recommendation to do pass.
There is an objection on the motion as a recommendation to do pass. On the motion that we rise in the committee of the whole with the recommendation to do pass, there being an with amendments intact.
Mr. Chair, is that an option? Maybe legal counsel that the motion would be to rise, and I think we've done this in the past where there wasn't any recommendation; it was just to place it on the third reading.
Correct.
I would prefer we do it that route with all the amendments intact.
So you're withdrawing your initial motion, Senator Rodriguez?
That's right.
So the motion's been withdrawn to rise in the committee of the whole recommendation to do pass, and has been amended to rise in the committee of the whole with the recommendation to place Bill 350 on the third reading file with all amendments intact. Clerk, are you good with that? Okay. Any objections? Without objections, the committee of the whole is dissolved. We will now rise to the body at large and yield to the acting speaker. Thank you, colleagues.
We are back on second reading. Senator St. Nicholas, you are recognized.
Thank you, Acting Speaker. Madam Speaker, the Committee on Appropriations has risen from the Committee of the Whole with the recommendation to place Bill 350 with amendments intact on the third reading file for action by the body. I hereby motion that we follow that recommendation and recess until 6 p.m. tomorrow morning for voting purposes on the third reading file. I'm sorry, tomorrow evening. 6 p.m. tomorrow evening.
I think we need to separate the motions. On the
Sure.
motion, on the
Motion to rise.
recommendation,
Recommendations and amendments intact.
the recommendation to place the third bill, the bill in third reading with the amendments intact. Is there any objection to that motion? Hearing no objection, motion carries. We are now on the consideration of the daily file. Senator St. Nicholas, you are recognized.
Notwithstanding the House rules, Madam Speaker, I'd like to make a motion that we recess until 6 p.m. tomorrow for the purposes of entertaining the remaining items on the agenda in the third reading file.
Right. Senator Torres, is there
Madam Speaker, may I request that the time, if possible, the time be moved up? I have a prior commitment at 6 that I'm heading, so it's going to be very difficult for me to even a little bit of consideration.
We're just trying to give council and the clerks time to, it ended up to be 7 bills on third reading now. So it's 5 p.m. They said they might be able to do 5 p.m.
Yes, Madam Speaker.
Would you
please? Thank you.
So amended, Madam Speaker.
All right, on the motion to recess until 5 p.m. tomorrow for voting. Any objection? Hearing no objection, motion carries.